Dear colleagues and guests, we are starting the procedure of thesis defense of Elena Igorevna Matsenko for the degree of Candidate of Legal Sciences on specialty 120005 Labor Law, Social Security Law on the topic social protection of individuals in clinical trials of the medicinal products for medical use. There should be official persons, and these people were officialized by the order of St. Petersburg State University from June the 2nd, 2017. This order, I was appointed. My name is Evgeny Borisovich Kokhlov. I am Doctor of Law, Head of the Department of Labor Law and Labor Protection of St. Petersburg State University, and I have all the necessary backgrounds to be the chairman of this dissertation board. Besides, the members of the dissertation board are Knyazhev Sergei Dmitryevich, Doctor of Law, Professor of the Department of State and Administrative Law of St. Petersburg State University, Yulia Vasilyeva, Doctor of Law, Head of the Department of Labor and International Law, Perm State National Research University, Yelnik Nurgaleva, Doctor of Law, Professor of the Department of Civil Law Disciplines of the Eurasian University, named after Gumilev, Astana, Kazakhstan. Galaganov Vladimir Petrovich, I have already mentioned him. Unfortunately, he is absent for very decent reason. As I have already mentioned, he submitted his report. I will read it out. I would like to remind you, in accordance with the federal law, from 1996 on science and the state scientific and technical policy, St. Petersburg State University has the right to independently award academic degrees. This order was issued on the 1st of September 2016. I would like to clear up some moments. The meeting of our council is considered eligible if at least 2/3 of the approved membership of the dissertational council takes part in its work, but not less than 4 persons. There are 4 members of the council, thus there is a quorum. And we have an opportunity to start our work. Sorry for my long introduction, but it's a rule. The procedure of today's meeting of the dissertation board, with a total duration of no more than 2 hours, is the following. I have to announce the main documents submitted by the candidate. Then comes brief report of the candidate for the degree, not more than 15 minutes. Then questions to the candidate, strictly according to his report. Responses of the candidate, reviews submitted. All the reviews were posted at the website of St. Petersburg State University, and this gives me the right to announce only questions and remarks concerning the reviews. And as for Galaganov Vladimir Petrovich, who is absent, I will have to read out his report. Then each member of the dissertation board will deliver his report. We have one external report from Ivanov Roman Alexeyevich. And then we will consider whether the candidate will answer each report or the list of them. And then we will have non-official open discussion, and not only the member of the board, but everybody who is present today will have the right to deliver his speech concerning the topic of the study. I would like to ask those who will hold the speech, they will have to register on the register list, and it's necessary to represent yourself, and then the candidate will give the answers to the questions. The scientific supervisor will have the speech within 3 minutes, and then the most interesting part for the candidate, it's voting, open voting. And according to the results of the voting, we will turn to our concluding part of the meeting. Please switch off your mobile phones. Or please switch off the sound, not to interrupt the candidate. And one more moment. According to the regulations and rules, an audio and video recording of our meeting is being conducted, as well as a live broadcast on the website of the university, and simultaneous interpretation of speeches from Russian and into English, or from English into Russian, is also provided. Let me start the procedure of the meeting. The first point is the announcement of all the official documents which we have. The dissertation of Matsenko Elena Igorevna for the academic degree of candidate of legal sciences on specialty 120005, labor law, social security law, on the topic social protection of individuals in clinical trials of medicinal products for medical use, is accepted for the defense by the order of the Scientific Secretary of St. Petersburg State University from the 6th of June 2017. The candidate submitted the following documents to the Scientific Secretary of St. Petersburg State University: an application form addressed to the Rector of the University, Professor Nikolai Mikhailovich Kropachev, about the acceptance for consideration and defense of the thesis, the report of the Scientific Supervisor, Professor of the Department of Labor Law and Labor Protection of St. Petersburg State University, Doctor of Law Diveeva, a list of publications containing 6 works which outline the main scientific results of the thesis, including 4 articles published in peer-reviewed scientific publications, a certificate of study dated the 4th of January 2016, issued by St. Petersburg State University, proving that candidate in the period from the 10th of December 2012 to the 1st of October 2015 took a postgraduate course in St. Petersburg State University, and 3 candidate examinations were successfully passed: labor law with the excellent mark, foreign language with satisfactory mark, and history and philosophy of science with a good mark. The conclusion on the recommendation of the thesis social protection of persons in clinical trials of medicinal products for medical use. A graduate diploma from St. Petersburg Academy of the Ministry of Internal Affairs on specialty legal studies with the awarding the qualification lawyer in 1997. The thesis is done in Russian and English, both in paper-based version as a manuscript and in the electronic form. All the documents comply with all the requirements. Let us start. Please, candidate, take the floor. Dear members of the Thesis Council, all present. The dissertation Social Protection of People in Clinical Studies of Medicinal Products for Medical Use made it possible through scientific research to consider for the first time in legal science the issues of social protection of those who participate in clinical investigation, including the context of ensuring the safety and efficiency of medicines in the interest of the entire population in the country. The purpose of this work was a comprehensive analysis of the legal status of clinical investigation participants, their social risks, the definition and evaluation of the effectiveness of legal mechanisms of social protection of direct participants in this research. The achievement of the goal was ensured by setting a certain range of tasks. Thus, as a result of the analysis of the activities of the Russian states as a social one in the context of medicinal provision of the population, an approach was proposed and justified in which the term drug provision is considered as a part of the state's social policy aimed at preserving the life and health of citizens, which is carried out by assigning to the state the obligation to carry out a set of economic, organizational and legal measures that ensure both the provision of medicines to all citizens. In this part, the category drug supply comes into contact with the category drug safety, which in the thesis is disclosed, on the one hand, as the right of the population to have access to medicines of proven efficacy for the treatment of a disease, and on the other hand, how the safety of these medical products for the organism implies the risk or benefit ratio from its taking to the patient. Adequate drug provision of the population must be guaranteed by the state through all the steps defined in the law on the circulation of medicines. Clinical studies of medicinal products for the medical use are the final stage of drug development, during which its effectiveness and safety for patients are investigated. This determines the high social significance of the CI process, which is both a stage of drug circulations and a guarantee of drug safety. CI serves the purpose of achieving the public good, but at the same time, in the process of conducting them, which is very important to emphasize, medical assistance is provided as a rule within compulsory medical insurance to specific patients who are specimen and who receive treatment with the most modern and innovative drugs. The research organizer is pharmaceutical company developing new medicines, medical organization that has concluded a contract for conducting clinical trials, a medical researcher who is an employee of the medical organization who directly conducts research, as well as a patient who takes part in this medical experiment. At the same time, based on the target orientation of this activity, a new collective subject of legal relations was established, which is an indefinite circle of persons, potential drug users, who are not directly involved in the process, but indirectly involved in it by their dependence on the results of the clinical investigations. Such an approach is due to the very history of legislative regulation of investigation, since the need for legal protection against dangerous and inferior medicines of potential consumers was paramount, and only decades later legal norms were introduced regulating the patient's participation in clinical investigations as a subject of the experiment and creating legal protection for the subject. That is, the movement of legal matter in this context occurred from the general to the particular. The method of deduction, which involves the transition from general ideas to private conclusion. The analysis of public relations in the field of clinical investigations allowed to identify and consider the features of this process that affect the construction of legal mechanisms for the social protection of individuals. Among them, firstly, a conflict of interest of participants embedded in the essence of clinical investigations. The very nature of the relationships between the researcher and the subject is such that their goals are significantly different. For the first one, the acquisition of new knowledge is of high importance. The second one, of course, is interested in getting medical help to improve their health. In addition, there is a certain conflict of interest in the relationship between the research organizer and the patient, because from the point of view of profitability, the drug market is in the third place after the sale of weapons and illegal drugs, and therefore pharmaceutical companies are always interested in quick release and greater realization of new drugs. At the same time, it is proved that the risks existing in the course of clinical investigations, both for the patient and for the investigator who treats with the experimental drug in the absence of reliable data about its effect, have an obvious social character. It was found that relations of the sphere of CI are subject to various social regulators, the problem of effective combination of which is actively discussed by representatives of different fields of science. Despite the connection of this activity with numerous legal norms of different branches, social security, labor law, and so on, the CI process is currently being carried out in many respects by ethical ideas which cannot be considered effective. These essential features predetermine the need to build social protection of the subject of CI with the help of effective legal mechanisms. Such protection is defined in the work as a system of legal measures aimed at the sustainability of the social situation and achievement of balancing the interests of CI participants, the investigating physician and the patient, by applying preventive methods of protection against social risks that are unavoidable in an experiment involving a human subject, and in case of such risks that minimize and compensate for their consequences while ensuring the reliability of the research results to protect an unlimited range of people, potential consumers of medicines. The content of social protection is considered through legal measures to protect individuals directly involved in the research process, as well as social protection of an unlimited range of persons. As for other participants, the organizer of the study, the medical organization, then of course they are not talking about their social protection. But taking into account such interests imposes a clear imprint on the choice of legal protection measures for other participants, individuals. Legal mechanisms for the social protection of individuals are analyzed through the category of legal means, because taken in together, they provide a productive impact on public relations. Special attention is directed to the disclosure of the intersectoral nature of the social protection of individuals in CI, due to the fact that legal means mediating it are closely intertwined, since public relations are regulated by various branches of law. Thus, social protection is a legal construction that provides a symbiosis of the mechanisms of public and private law. The chosen approach allowed to analyze the specifics of the legal regulation of this activity, and also for the purposes to determine the effectiveness of legal mechanisms, study the practice of law enforcement. For this purpose, legal mechanisms are classified in the work in accordance with the functional orientation, the way to influence social risk, to preventive and compensatory ones, which is consistent with the principles of constancy and continuity of social protection at all stages of study. According to the analysis of the order of legal activity on the protection of subjective rights, legal mechanisms are differentiated into jurisdictional and non-jurisdictional ones. Our research produced some principal conclusions concerning the effective measures of social protection of individuals in clinical investigations. Such the preventive legal mechanisms for the social protection of patients in CI is ensured by strict compliance with regulatory requirements for the organization and conduct of CI, compliance with the regulations and standards of medical care, and may be referred to as preventive public legal mechanism. Compensatory legal mechanism for the social protection of patients today comes solely to compulsory life and health insurance for patients in CI under the civil law regulations. Proposed by today's legislator, exclusively private law means it's almost impossible to protect an unlimited number of persons from dangerous drug. The paper proposes an adjustment of insurance legal measures of protecting patients to a greater extent in the public law plane. In addition, another direction is proposed to improve the compensatory protection of patients in CI, which is practically absent in the current legislation, the application of special social support measures to them after the end of CI related to additional guarantees of medical care and drug provision. Considerable attention is paid to the development of legal mechanisms for the social protection of a doctor who conducts CI, since his professional risks are social risks. Based on the system analysis of Russian legislation, the conclusion is made that it is impossible to conduct CI outside the walls of the medical organization by private practitioners. Today, a doctor researcher must have work legal relationships with the medical organization that has concluded a contract for CI. Such mechanisms are determined by the application of the norms of labor law as a social sector rather than civil law norms. There is a conclusion about the relationship between legal mechanisms of social protection of individuals in CI, the effectiveness of each of which affects the effectiveness of the other. Thus, in the implementation of preventive measures for the social protection of patients, a preventive social protection of the investigating physician is carried out at the same time. Conclusions made in the study can be considered as current and effective proposals, allowing to make changes to the legal framework regulating clinical investigations. The timeliness of such proposals is also confirmed by the fact that during the writing of the dissertation research, the legislator adopted important normative legal acts, such as the Rules of Good Clinical Practice of the Eurasian Economic Union, approved by the decision of the Council of the Eurasian Economic Commission on the 3rd of November 2016, on approval of the procedure for pharmacovigilance aimed at building and strengthening control over unforeseen, undesirable reaction of patient and deaths during CI, which did not occur previously. Also, at the level of the bill, changes are made in the Code of Administrative Offences, which for the first time introduce administrative responsibility for violations committed during the CI. Such legal innovations are aimed at strengthening social protection measures, both of a patient and through the requirement of transparency and reliability of the results of the study, the entire population of Russian Federation. Thank you very much, Elena Igorevna. Dear colleagues, as I have already mentioned, the procedure implies the question and answer session from each member of the meeting.
The question is this. I am going to translate, because I have the microphone. Dear Elena Igorevna, do you differentiate the notion of clinical test and clinical research, or are they identical? And the question is from Professor in Law, Victor Borodin. Thank you very much for your question. The clinical test and clinical research talk about the same process and are identical. There are different terms that are used, and they come from translation differences, and so the research is used when in translation, but clinical investigation and clinical tests are used in Russian legislation. I have an additional question. Well, the microphone is not used. At the beginning, the correlation is absolutely identical. When I started my presentation, I said that both terms are used in legislative acts at the official level, and I make a caveat of that, and the work is presented as clinical tests or clinical investigation. Any other questions? No, there are no raised hands. Well, thank you very much. I think you persuaded the audience, and the name of your paper is quite clear. Thesis is quite clear. I think that some questions may arise during the process of the defense, and now we're going to start an official discussion that used to be called these reviews from the members of the Dissertation Council, and maybe we'll start ladies first. Professor Vasilyeva, whatever. If you talk from your seat without saying, I mean, obviously your microphone is on. Yes, please. Please, the dissertation candidate, please take your seat. Dear ladies and gentlemen, I'm very happy and I'm honored to be part of this session, this meeting, and to be a reviewer and member of the Dissertation Council of such a renowned university as St. Petersburg State University. And I would like to bring you greetings from the oldest Ural University. Perm University marked 100th centenary anniversary last year, and personally from the rector, Professor Mikhailov. As we all heard from the presentation, the strengthening of public health and the development of healthcare are inalienable parts of the healthcare policy or the security policy of the Russian Federation. Over the past 10 years, a number of strategic laws have been passed, and strategy of national security and laws on healthcare and on medical provision, etc. And they all talk about the safety of medications and the strengthening of the control over the regulation of the sphere and the control over the quality of this. And we think that in 2020 we aim at not less than 50% for Russian-produced medication in the Russian market, and one of the most important roles in producing this safe and high-quality medications is played by clinical research or clinical tests. Clinical tests started later in Russia than they had in the other countries, but we now built a framework, a legislative framework, but medical research for medical procedures, but the clinical research still lack a legal framework, and the legal regulation of the medical practitioners and social protection for doctors. Dissertations of 2014 by Sokolova, Professor Sokolova, that had to do with the compensation of professional risks for doctors, and 2008 Evgenia Astrakhantseva defended a thesis on legal regulation of medical practitioners, and in 2016 a dissertation by Maria Alexandrovna Podvesnikova defended a thesis on medical protection. Maria Fedorova and Evgenia Machilskaya also drew our attention to medical provision and healthcare, and this is all the foundation for the research made by the applicant, by Matsenko, and this is the first comprehensive research in the Russian Federation that talks about clinical research and the legal protective mechanisms for it. Because this is a new field in law, and in this term, in this way, this paper really contributes to the legal to the discussion in this area. As far as the my review, first of all, I would like some commendable. What's commendable? And the dissertation is well structured. Logically, the first chapter formulates main thesis. And in the second and third chapters, the author talks about the patient protection and doctor's protection. And the strength of this thesis is a balanced approach to the combination of the juxtaposition of public and private interests. This is a very controversial topic and has no resolution, and there are very heated debates, and the author went between the Scylla and the Charybdis and talked about the patient's work, patient's protection, because it's regulated by administrative, by civil law, and I wouldn't agree with all the conclusions, and I will talk about it, and the author advocates a more strengthened social dimension of these protective mechanisms. Elena Igorevna also stressed a comprehensive approach to clinical tests and to the social protection of patients, because she studied this process not as far as the legal norms of the Russian Federation, but also international law, and also professional ethics acts, and also drew on international experience, and of course it has a longer history than that of Russia in clinical research. As there are other points that I cannot help commending, but probably I will stop my remarks in terms of praising the dissertation and then turn to some critique. Of course, as any new research, the dissertation has controversial points and maybe not too enough argued. Maybe they need some more arguments, and Elena Igorevna will probably answer the questions that I will pose, and some parts are very controversial at this present time, and of course we may not find all answers to all my questions, but we'll see. And the first question is, Elena Igorevna proposes some statements, original statements about social, and talks about the novelty of this proposal. I wouldn't agree with all of them, and especially the definition of provision of medication in the broader terms that she proposes. She wants to include the medical provision, a more social protection notion. The current legislation states that it uses a narrow definition of medical provision, and the author wants to expand this to a state function. Well, of course, this is important. This is an important thing for national security, and I agree that in terms of doctrine, you can look at it from different points of view, but from the point of legal terminology or legal framework, this broad definition will not be effective, because the concept of medical provision, according to the author, includes all stages, including production and then up to the disposal of it. And you can see that all these stages should be regulated by different legal acts, but also by different legal fields. And this is my first question. And the second question, I share her concern about the inadequacy of compensatory mechanisms and protection. And of course, I agree with the civil regulation, but I would rather not agree with the author to accept to term the medical insurance, mental medical insurance that exists as social type of insurance. Maybe we should strengthen these compensation mechanisms in terms of, because we shouldn't really term one type of insurance by a different type of insurance, by a different name and different field, because medical insurance is not identical to social insurance, and even at the national level. Just a few words about the history of social security. It first appeared as a form of protecting the relations between the employer and the employee. And in this case, the social risk, the notion of social risk cannot be applied in a broad sense to the human life in general, because the risk is social risk is not possible to protect it from, and so therefore social risks are en masse, a massive phenomenon. The difference is the objective character of such risks, and the scope should be sufficient large in order to make the employer pay certain deductions to the medical insurance fund, and of course we have conventions of the International Labour Organization are now accepted as part of the Russian legislation on social and the medical insurance, and maybe the author should look at the different ways of strengthening the mechanisms of social security, and maybe look at the current legislation for that. And I liked her idea is the deferral of the time of proof, the burden of proof for the risk from the patient to the medical organization, and there should be a clear connection made between the death and the clinical tests. And maybe maybe we could use a mechanism from social protection security. Maybe that has to do, for example, with the servicemen, and because the author advocates a broader function of the state in this sphere, maybe this is a way out. And the last principal criticism is this. The author consistently advocates the interrelationship between social protection of patients and the social protection of an unlimited number of third parties. And of course with some points I can agree, because clinical tests are used to market a safe medication, but the interests of a broader public or users of this, to equate the compensation of the patient and the end user, we cannot really do that. And so I had this question: what ways can we use the medical insurance mechanisms and compensation mechanisms be applied to an unknown party? And so how can it protect the users, the public, from the unsafe medications? I don't see a clear mechanism there. And of course, this is a unique and a very original research in the field of social protection, and therefore, after reviewing it, I concluded that the thesis social protection of persons and clinical tests has a broad research field. It contributes to the field of the labor code, labor legislation in the relevant area, and the content of the dissertation manifests that it's been written by the author. It's an original research, and the work is consistent and cohesive, and it complies with the standards of the order on dissertation defenses in St. Peter's State University. The work has a theoretical and practical importance, and so the work stands the verdict, the positive verdict of awarding the degree that the author aspires to. So, well, we'll continue. Elena, please. I would like to first thank the Department of Labor Law of St. Peter's State University and Evgeny Borisovich, you personally, for the invitation to take part as a reviewer in this dissertation research. I really enjoyed reading this dissertation, and for the possibility to talk to my colleagues and discuss the ideas that I have, they have, and so on. And I'm very happy to be back in this university. Dear colleagues, dear members of the Dissertation Council, it was very interesting. The thesis was very interesting, and I had to sacrifice some of my personal time, and the previous reviewer concentrated in detail on the content. But I would like to stress that the Russian Federation and Kazakhstan, we had recently moved, the Kazakhstan 1996 as a recent field. 1996 is when Russia adopted its technical standards in this field, and it's been very recently, and so we cannot jump over stages. And in Kazakhstan, especially in 2010, when the law on medical medicines was adopted, so it's even a new field in Kazakhstan. So in terms of the timeliness, the originality of this work, I can say that protection, the clinical research, of course, increases the safety of medical of drugs. In the United States, 100,000 people currently, on the other hand, 100,000 people die currently in the United States as a result of clinical research, and so there are health risks. And of course, Russian and Kazakhstan patients also are subjected to risk. Unfortunately, we have no data, and it doesn't matter. It doesn't mean that what we quote from the United States is that we have fewer cases, and therefore we just don't know. And so therefore, of course, such cases led to the significance of social protection, and as a person is very vulnerable when he takes part in clinical research, and we have to provide guarantees to protect the patient's health, and the state and the public have not been ready for such a fast clinical research development, and therefore these legal relations and social relations are not covered by legislation in due scope. And of course, all the risks and all the results that occur during the clinical tests, and also who are also potential, and the people who are potential users of such medical medications, talking about it is very important, and that's what is done by the dissertation author. And of course, I would like to say a few words about to what degree the dissertation complies with the standards of to the dissertation applied to the dissertations at St. Petersburg State University. And of course, the statements to be defended, number 10. And I analyzed all 10 statements, and when you look at these things, and of course, and because they're new, I try to see whether they are substantiated in the text. And of course, I have a long, detailed review, and it's uploaded on the site of St. Petersburg State University, but I'll say briefly here, in the previous review said that a broad treatment of the term medicine is advocated. I support this broad treatment, because medical provision is a social responsibility of the state, because if the state doesn't take this responsibility, look at what has happened in the former Soviet Union. Up to 70% of medicines are counterfeit, and or they do not comply with the standards, and these medications don't help the patient or even produce harm. And of course, the state has to take the responsibility to protect the health of the user, the patient, and the treatment. And the broad treatment is based on the social importance, because I like the way the author said that because this medication affects the health the health of many people, and unlimited number of people, whoever is going to buy it. And of course, when we buy this medicine that has gone through clinical tests, we should be sure. And therefore, I totally support the idea that that social protection should cover the end user as well. And of course, and author also said that legal regulations should be applied to every stage of working on a new medicine. And of course, cases are cited. And the author tries to argue, and I think that the arguments are valid. And I also looked at the law in Kazakhstan on national security. Medical security is part of national security, and unfortunately, the national security doctrines, in Kazakhstan, only 2 sentences are included, and in other CIS countries also have some kind of disregard of this field. And on page 29 and other pages, the author tries to advocate that medical provision is part of national security. And the statement, the next statement about the protection of doctors is then substantiated with the existence of national medical standards of education, national curriculum, and this proof, this evidence is quite sound. And also she talks about the vulnerability of the patient and the guarantees that should be provided for unfavorable results, and again, the connection is made to the end user, and again, this interrelation permeates the whole dissertation of the patient, the relation between the patient that's subjected to clinical research with third parties. And I believe that this is a very important point, because I feel that I am protected here as well, because I will not go over the whole list of 10 points, ideas, defended ideas, but I will just say that all the risks are social, according to the author, because they can ruin the health of the person, and the second, and the doctor's responsibility, the professional responsibility, and the second is because the doctor carries responsibility not to harm the health of this, and this is important, because the doctor should be vested with this responsibility and protected as well. And of course, the previous reviewer talked about the labor regulation between the employer and the employee, and the applicant made sure that she proved that there would be regulation, there would be oversight over the oversight from both the medical organization and the doctor on the safety for the patient of this clinical test. And this is, I would like to also mention a few things. The question is whether the existing legal norms whether the legal norms present a comprehensive protection for the health of the patient. Well, of course, we have a lot of laws and have legal norms, but even this legal body, according to the author, deems it inadequate, because there's no clear mechanism of how these legal norms are implemented. And of course, the author cites international conventions and some legal research of professors that study these legal acts. And she makes a point that it's an interdisciplinary area, and because it's a symbiosis of public and private law. And I think it's a valid point, and I believe that only using the legal mechanisms of private law, civil law and labor law, you cannot really provide adequate protection. And so we have to attract the regulations that are specified in public and private law laws, etc. So just about, well, I of course made all other comments about the rest of the statements, but maybe I would like to now provide some critique. As far as the originality of the research, I think in terms of monographic, at the monographic level, this research is comprehensive. As far as the recommendations, I made many recommendations. I will only mention three. The legal essence of clinical research should be characterized by the conflict of interest of the participants of the process, and especially corporate interests, and especially at the stage of the contract of medical provision that is signed by doctors and the medical organization, because the doctor may look for preferences and privileges, and may sign a contract that would not lead to impartiality. And second, and also social protection should not be only just social protection, but effective social protection. And again, it should encompass the end user. And also identifying the main problems allows us to define involve the end user in this process. So the proposed conclusions are well argued and have conceptual originality and theoretical solutions and practical recommendations, but of course the dissertation lacks some points there. The author says that because there's entangling of the interests of the doctor, the patient, and the medical organization, there should be a number of instruments developed that would regulate the tripartite process. And of course she talks about even the the criminal liability. I don't know about Russia, but in Kazakhstan, any protection, any kind of protection has practical relationship with legislation, and especially when these laws are amended, in research such as what we're discussing should have current laws. And in our parliament, there's a bank of legal acts, and because I am a former member of the Parliament of the Republic of Kazakhstan, any researcher can draw on them, can request them, and in this research lacks concrete numbers of laws. She says that you should amend this, you should amend that, but not citing any. Not all laws are cited. Well, as far as the ethics, we should the ethics committee of the State Duma, and well, of course, the committee of ethics, such an ethics committee should be created for any clinical research procedure or project. Of course, it is a very good idea, but could you specify what exactly is the responsibility of existing ethics committees? But it should be so. This analysis should be supplied where clinical research is done in the regions. Maybe some ethics committees actually exist. And one more critique, and you cite the decree of the President of the Russian Federation dated prior to the year 2015, when it was actually replaced. And you thought maybe the doctrine of national security is till by the year 2025, and you thought that this law is in effect, but it is not. But in conclusion, I would like to say that the research that we're discussing on the topic social protection of persons and clinical tests of medical medicines for medical application complies with the standards for the dissertation defenses at St. Petersburg State University, and the author of this dissertation is entitled to being rewarded the sword degree of the candidate of legal sciences. So we continue.
Professor Knyazhev, please take the floor. Thank you very much. My task is much easier now. We have to consider several moments. Well, we have a time limit of 2 hours, and I will be as brief as possible. Besides, I'm the professor of the department, where before I was a postgraduate student and defended my own dissertation, and now I am a judge in the Constitutional Court just across the river, and most part of the judges are the professors of our university. And we came to a conclusion that we have to get rid of professor habits, not to deliver speeches for 30-40 minutes, In this sense, I will try to be brief, and you know that at the site you may see the written review. The topic of the thesis is quite relevant and significant and rare. It's obvious that we are present not for the first time at the defenses of the dissertations. The candidate managed to find in her study a peculiarity which before had not been the subject of research. And you see that the topic of the research is quite relevant. If we take this second article of the Constitution proclaiming that all the rights and liberties of a person are equal, nevertheless, on the whole, if we take the spectrum of the rights and liberties of a person, the Constitutional Court underlined that the life and health of a person and citizen is a social welfare without which other rights and liberties which are guaranteed by the Constitution become useless. And if we take the medicinal provision of the health of the population, they become very significant. And I think that this problem should be investigated because judicial practice and legal practice has not been yet formed, and it needs explanations and conclusions which the candidate has made. If we address new medical technologies, the court considered questions with maternity, and the topic of the candidate is very new and relevant. Nowadays, our constitutions has no gaps, and it means that all the issues and problems has already been solved in it, and any area regulation with the help of legal institution can't neglect the requirements of the Constitution. The thesis is completed at a very high level. Interdisciplinary approach was applied, and the author has not lost her own approach concerning social welfare and social security, and the attraction of constitutional material and so on gave the opportunity to conduct a complex and comprehensive research. The main advantage of the thesis is it is an academic and theoretical investigation. The author does not avoid utilitarian approach. Those who write thesis don't set a task to investigate the peculiarities of legal activities. I'm not going to insist on the fact that any candidate should use some real ideas from the articles which exist. And then, according to the responsibility of lawmakers, we may be sure that the conclusions which the candidate made are very important. Well, I'll try to be as brief as possible, and I have several remarks. There are some questions of controversial and problematic nature. They are as following. The candidate defines the medical provision and views it from different angles. It is quite right and allows the candidate to say that this wide spectrum of medical provision should be viewed in connection with human and social rights of those who take part in correspondent clinical research. And I want to know how the candidates imagine the peculiarities concerning human and social rights of the subjects of people who receive medicines. Is there any difference, and how can we characterize the rights of those who receive these medicines? Are these rights real legal opportunities of a citizen, and whether they are guaranteed, or it is something which is the right which governmental bodies should provide. The second point is the sphere of medical provision. When we are talking about clinical investigation, is at risk. And if there is such a risky character, there is an opportunity to do harm to a patient and violation of rules, and the candidate's idea is explained in terms when the administrative responsibility is used. Should we divide the criminal responsibility and administrative responsibility? In this case, whether it is a penalty, or ban for conducting clinical investigations for some time. I advise in this context for a candidate to explain why this special responsibility like ban for clinical investigations is necessary, and what is the difference between them. And finally, One more question. In the thesis, there is a conclusion that the provision of effective measures of social protection of people who take part in clinical investigations such medicines have received clinical testing, and the cause and effect has not been researched in the thesis, and that's why what is the protection for the people who take part, unlimited circle of people who take part in this clinical research. On the whole, I think this thesis complies with the requirements. Moreover, it has many advantages, novelty, interdisciplinary approach, as I have already mentioned, and constitutionally oriented methodology of the research, and of course practical and applied significance of the work. And I'm sure that the author of the thesis, Matsenko Elena Igorevna, deserves the degree. Thank you very much. Dear colleagues, I support the idea that we have to be brief. Well, you see, I have to read out some reviews, and please be patient and try to understand. As I have already mentioned, Vladimir Petrovich Galaganov, he submitted his report. And according to the rules, as he is absent, I have to read this report. Vladimir Petrovich, on the whole, outlines his report is positive. He marks the scientific interest of the thesis. He devotes some parts of his review to the scientific interests and novelty of the paper. He writes that the candidate researches the social security of people who are under the clinical investigations, and social protection of the population is viewed as a complex measures of social relationships, in the course of which a person is involved into this or those means of protection. And if we characterize the clinical investigations and as a social process, the candidate explains working relationships, of course, critical characteristic of clinical use of medicines is stated, and the author of the review states that such conclusions are quite new directions in scientific search. It means that the paper is quite relevant, and also it has theoretical and practical significance. The candidate defines the term social protection of people who take part in clinical investigations. According to Vladimir Petrovich, this definition has some drawbacks, but he does not mention these drawbacks. But on the other hand, he says that this definition is a new one and have some properties. Social risks of the participants, the necessity to take preventive and compensational measures, interaction of these measures with the measures of social protection, the position of the author at the beginning of the thesis is quite uncertain concerning public and private areas of law. The approach to the research of the author is quite explained. Including social protection. A complex approach of the authors to building the mechanisms of social protection. They combine public and private beginning. A lot of legal methods are listed. Processual, for example, which have processual order. With their help, a candidate will be able to study. One more advantage of the thesis is the comprehensive study of protection measures. There are some other elements and conclusions which must be supported, and the statement for the defense has scientific novelty. But there are some remarks. First of all, if we consider such notions as social protection, social security, the author sometimes can't explain exactly the meaning of them. The first, social protection of population, is viewed as a set of protection of working and disabled people according to state standards and according to the law. The title of the thesis is a social protection of the people who take part in clinical investigations, but the candidate considered in her paper legal aspect of these investigations. The second remark, in Russian legal doctrine, the risk means death or lack of health, which involves the inability to earn money. But the author views this issue in more wider. This comprehensive explanation requires additional argumentation in the course of public defense. And the third remark, the modes of social security are explained by Russian legislation, and it is necessary to include the insurance of life and health of patients who take part in clinical investigations. And the candidate states the social nature of this necessary insurance, social insurance. Why social and economic risks are posed by the candidate. And in this relation, and the general conclusion is that these remarks were caused by the novel approach of the candidate to the research. Elena Igorevna Matsenko deserves the degree of specialty 12005. In the documents submitted for the defense, there is non-official opponent's review. It was written on behalf of the organization and signed by the vice president of a closed joint stock company by a cat. It is situated in Moscow region, Krasnogorsky region, the village Petrova Dalneva. Roman Alexeyevich Ivanov. I have we have got half an hour.
The review says that the topic is very important, not only for legal specialists, but from the pharmaceutical professionals and medical professionals. And of course, he states that he represents a pharmaceutical company, that United Research Center in Medical Science and Pharmaceutical and Biotechnological Production Facilities for clinical research that are carried out according to. So this the name of the biocard, and so this self-advertising campaign part has to do with the fact that they want to prove that they're relevant because they produce and do clinical research on a wide range of drugs. And of course, this paper is research paper is very important for them. And they cite some problems that they don't have enough legislative regulations that would regulate their work. And so they say that the theoretical analysis in the thesis was quite comprehensive. It related to the current legislation and some criticism of that, and they agree with those criticisms, but despite this, they formulate their own criticisms. First of all, in order to endorse the mechanisms proposed, well, there was no wind. Yes, probably the force of the mind of the author. And so the dissertation proposes that the patient has the status of the subject of social protection, and the author talks about the responsibility of the insurers to inform mandatorily about any complaints, insurance complaints or requests for insurance that they received, and the authors of the review think that this was quite a reasonable proposal, and this is also. And this is good on face value, but also they state that no mechanism is provided and no detailed description of how this can be done. The second critique has to do with the burden of proving the harm that is now carried by the patient and the relatives, but to place that on the medical organization and placing that burden on the insurance company to prove that there's no fact, that there's no connection between the clinical between the clinical tests and the results, the negative results. And if we do that, the insurance company will have to prove the absence of the fact or the negative fact that this connection exists, and therefore they will actually act against themselves. So no existing models of insurance systems has that, because there's a principle of justice and fairness that is broken here in the proposed idea. And there's also some unclear gray zone about the liability of the insurance companies and the burden. What about those insurance companies that had nothing to do with providing insurance or whatever, and so therefore practically this would increase the price of insurance policies, because this would include also this work that the paperwork and other things that the insurance companies would carry. And so in general, the thesis is a comprehensive piece of research that has to do with that covers the social protection in the medical sphere and clinical research, etc., etc. And of course, this general conclusion is then detailed, and the final conclusion is that the thesis fully complies with the standards, and the author is entitled to being rewarded. We've gone through the 2/3 of this session. I would like to it's going to be very short, and in terms of my own conclusion, and my colleagues already stated all all the comments that I made in my review, so I don't want to repeat themselves. Well, in terms of the positive comments, this work was done. I was just watching the work unfolding, and I liked the author's work, and I think that the dissertation completely meets the standards. And just only two comments. Critical comments. Well, my colleagues already stated that the work is interdisciplinary, not only because it's from on the borderline of two sectors of law, and but this is very good. But there's the backside as well of this country. Because this broadness, this multidisciplinarity has some drawbacks. It produces some unclear areas, especially in terms of the ratio where different fields of law are applied. So the doctor, researching doctor, is in a labor relationship with a medical organization. That's one thing. And the author suggests that we should ensure that, and of the health, the health of the patient, civil. And the civil responsibility stated in the criminal code, in the civil code of the. So who is responsible for bearing the responsibility? Of course, this is the employer. So, and where's the role of the doctor? And where's the place of the doctor here? And then the second question, wouldn't you think, and I address the applicant, if you treat social protection so broadly, the author extends social law on the whole field of law, and in all other respects, I totally support this. So, any question, any answers from the applicant, please?
Dear Chairman, dear members of the Dissertation Council, we should thank you very much for your reviews and critics and questions to my paper. It was very important for me to hear them, and I have already prepared the answers to these remarks. But having heard everything, and I would like to not to stick to what I have written, because I'm pressed for time. Evgeny Borisovich, such comprehensive explanation was born during the years of writing my paper, and I was greatly impressed by the conference on social law, where many people asked questions, and a lot of members of Constitutional Court had speeches, and it was a very fruitful conference. After this conference, I took part in Pashkovsky reading, and at the international level, we exchange with our colleagues our opinions. Undoubtedly, my paper, my research has some drawbacks as for the social protection, and this term usually contains legal and economic and organizational measures. First of all, I studied the legal regulations of social protection and how does this law work in the organizational way, and we wanted to know how this law as for the questions concerning the medical provision of the population. I don't want to talk about the fact that I tried to find some legal unit connected with some legal norm. I wanted through the category of medicinal provision connect it with some social purpose. Nowadays, the content of medicinal provision includes only issues of distributing the medicines between some poor category of people, but we are talking here about medicines which are available. But another side of the problem, we have to take into account the fact that new medicines should be developed for such diseases as hepatitis, tuberculosis, AIDS, and so on. They are the developments in this direction are of high priority. One short example. My doctors, oncologists told me one doctor lost his son at the age of 25. Vice President of the United States, it was his son, and his father had the opportunity to provide him with all the necessary medication. And this case urged him to change the approach to the development of the medication in the USA. Some changes were made in the legislation which led all private pharmaceutical companies develop medicines and conduct investigations, but secretly, and only those results are published when the medicines will be developed. And vice presidents managed to do the following. These efficient medicines, the commercial secret should be unfolded in the USA. Nevertheless, the USA has a program. Every organization work in close connection with others. And the patient should be insured when he or she takes part in such clinical investigations. at the legislation level. It was important to enhance some public and legal part which are stipulated in the social insurance. And with the help of that, to improve this public sphere concerning this insurance. And nowadays, relatives of patients have to go to court and prove that their relative got harm from such clinical investigations. And I think that if I answer the remarks of BioCat company, thank you very much for this review. It showed the conflict of the interests I have already mentioned. The organizer of the research directly states that it's not in their interests. They're interested when a patient or his relatives order medicines. And this conflict of interests illustrates the very essence of the problem. And in future, it will be easier to elaborate some mechanisms in order to help patients. Why I think that the civil responsibilities should be ensured. You know that the organization is responsible for every problem, and when it ensures every risk which are
they will be